a great privilege to join this panel. And of course, we all acknowledge that we have a good system, a good international framework based on international human rights law. And we have guiding principles on business and human rights. And so it will be very rewarding if we, the panel, focus on the gaps in implementation and the gaps in protection in this framework. So as I said, we had this framework, so it's surprising to me that it was only in 2013 that the right to privacy came to be considered before the UN General Assembly and the Human Rights Council, and that, as you know, happened after Chancellor Angela Merkel and President Dilma Rousseff complained that their personal mobile phones had been hacked. So digital communications technologies crucially benefit the protection of human rights, but they also come with challenges that undermine human rights, such as the invasion of privacy. So on the one hand, digital technologies facilitate global debate, they foster democratic participation, but on the other hand, they've enhanced the capacity of governments, enterprises, and individuals to conduct surveillance, interception, and data collection and sharing. And so the risk now is that state and non-state groups are developing sophisticated digital surveillance capability outside regulated controls. The GA resolution affirms that all the protections of human rights that we have offline should be introduced online. And so they asked all states to review their procedures, practices, and legislation relating to communication, surveillance, interception, and so on. And they called upon all states to ensure full and effective implementation of their obligations under international human rights law. So I mentioned international human rights law. The key provisions then are Article 12 of the Universal Declaration of Human Rights, which provides, let me quote, "No one shall be subjected to arbitrary interference with his privacy, family, homes, or correspondence, nor to attacks upon his honor and reputation. Everyone has the right to the protection of the law against such interference or attack." And then you have Article 17 of the International Covenant on Civil and Political Rights that uses the same language. So it's very interesting that the OISTE Foundation has raised some important questions with regard to the adequacy of protection afforded by Article 12. And important questions have been raised on how the protections are differently experienced, say on gender or LGBT, to which I would add poor and developing countries compared to rich countries. So it's a very interesting exercise to review the provisions that were put in place long before the digital era. The rapporteur, for instance, has invited public submissions on other aspects of human rights because the digital collection of personal data affects other human rights such as health data privacy, the use by corporations of personal data, and the effects of privacy breaches upon marginalized groups. Now, the human rights mechanisms have provided extensive guidance on what is privacy, what comprises interference and arbitrariness. Challenges arise over how to protect confidentiality and personal identities in the new and emerging market of big data collection. Metadata may give an insight into an individual's behavior, social relationships, private preferences, and identity that go beyond even that conveyed by accessing the content of private communication. So this risk needs to be countered by reform of existing policies and practices to ensure stronger protection of privacy. So the bottom line is that states must refrain from employing unlawful or arbitrary surveillance techniques. And there are a number of criteria as to what constitutes arbitrary and what is unlawful. For instance, you may have a national security law on protection, but if it's not in accordance with the international law and the aim of international law, then actually your national law will not be in compliance of international law and will be illegal. So applying all these checks and balances of international human rights laws, which I've just mentioned, lawful, proportionate, necessary, legitimate aim, respectful of other human rights, and so on, let me say that bulk surveillance programs fall short and they are deemed arbitrary, even if they serve a legitimate aim, and even if they were adopted on the basis of an accessible legal regime. So mandatory third-party data retention. This is where states compel internet service providers to store metadata about their clients' communications for subsequent law enforcement and intelligence agency access, is also deemed to fall short of these standards of necessity and proportion. Many national frameworks also lack user limitations, thereby allowing data collected for one purpose to be used for others, or allowing the sharing of data from different agencies. So such data sharing regimes have been struck down by many courts in many states. Unlimited sharing will not be in compliance with Article 17 of ICCPR. So in practice, many states have revealed a lack of adequate national legislation. The Special Rapporteur on the Right to Privacy reports that more than 1/3 of UN member states have no privacy laws at all, while most of the other 125 states have laws which cover some of the contexts where privacy may be threatened, but not all. Some important threats to privacy, especially those arising in the context of national security, intelligence, and surveillance, are inadequately regulated in most countries of the world. Now, with regard to business enterprises, we have the Guiding Principles on Business and Human Rights, which was endorsed by the Human Rights Council in 2011, but however, it's not a binding agreement. And, you know, it's just wishful thinking that business will comply with this, which means have a policy, have a commitment on protection of human rights. I'm happy to say, I was there during this right to privacy discussion for the first time, as well as the Guiding Principles on Business and Human Rights. So I'm well aware of the multi-stakeholder efforts to come up with due diligence standards and so on, oversight, exercise transparency, and so on. However, gaps in implementation of the guiding principles continue to be alarming, especially in relation to the sale and purchase of personal information of individuals. Massive increases in technological resources and inexpensive, potentially limitless cloud storage enable the storage by organizations of massive amounts of data on private individuals, and in many cases, use of this data is a source of revenue for them. To address this concern, the EU introduced the General Data Protection Regulation, GDPR, with global territorial scope. It provides data privacy of EU citizens and residents, no matter where in the world the company using that data is located. To ensure that organizations comply with the strict set of privacy rules, the GDPR imposes heavy penalties as high as 4% of a company's yearly revenue. But the good news is 60% of technology companies have put in place GDPR policy, and 20% are in compliance. And of course, huge fines have been levied so far, which show the reach and impact of GDPR. $5 billion fine against Facebook's Cambridge Analytica, the political research group that accessed the data of more than 87 million Facebook users, and others who were penalized with heavy fines included British Airways, Haga Hospital, Netherlands, Google, Vodafone, and so on. GDPR extends jurisdiction over companies located anywhere in the world, which is a welcome provision. Companies anywhere in the world who process the data of EU citizens and residents. And GDPR requires the consent of the individuals prior to the use of information relating to them. GDPR places limits on the amount and purpose for collection of personal data and the transfer of personal data from inside the EU to outside. And it introduces new data privacy rights, such as the right to know what personal data is collected, how it is stored, the legal basis for the collection, and who the data is shared with. And it has the right to be forgotten, whereby companies must delete all personal data upon request. It has built-in oversight mechanisms and data protection officers. So really a most comprehensive and advanced protection law on the right to privacy, on digital information, and one hopes that it will be emulated by states. I think my time is just going up. I want to mention that other countries have passed similar legislation, the California Consumer Privacy Act in the US, LGPD in Brazil, and in my own country, South Africa, Protection of Personal Information Act. Now, our South African law more or less follows the GDPR, but there are differences in that it allows cross-border transfer of personal information to a third party that is subject to legal or corporate data protection rules substantially similar to South Africa. So I do agree with the special rapporteur that you can't do this by national legislation alone without regard to the international context. The SR on the right to privacy concludes that an international framework with consistent data protection and clear rules for transnational access would help weigh privacy protections and the competing interests that nations may have in gaining access to data, for example, in the context of law enforcement, or that multinational corporations may have in managing data flows internally. Effective protection of the right to privacy in the context of modern communication technology will require our ongoing concerted multi-stakeholder engagement. So I look forward to the expertise that will come from my fellow panelists. Thank you, Colin.